Hello and welcome to the latest episode of the Retirement Cafe podcast, which is sponsored by My Financial Planner. Not knowing when you can afford to retire or what your pensions will provide can be worrying. My Financial Planner provides independent, fixed-fee retirement planning advice, bringing clarity to your financial future. At My Financial Planner, we build you a retirement plan, bringing together all your retirement savings and equip you with the knowledge of what improvements you can make. Find out more about getting a plan to fund the retirement that you really want at myfinancialplanner.co.uk. It's a common misconception that you make your will and that's the end of the matter. Sadly, for some families, they find out after they have lost a loved one that's not the case and the will can be challenged. Research suggests that almost a quarter of Brits would be prepared to contest a loved one's will if they were unhappy with it. That's where this week's guest comes in, Victoria Jones of Leicester Aldridge Solicitors. Victoria is a partner in the Disputed Wills Charity and Dispute Resolution team, where she helps resolve conflicts around contested wills. In our in-depth conversation, Victoria explains the four main reasons people contest a will and how to deal with a will that's been challenged at what is a highly emotional time for those left behind. She also shares important tips on choosing an appropriate executor for your estate and steps you and your loved ones can take to avoid becoming part of a contested estate in the first place. I hope you learned something from my conversation with Victoria Jones of Leicester Aldridge Solicitors. Welcome to the podcast, Victoria Jones.
Thanks, Justin. Nice to be here.
Yeah, really looking forward to us chatting. Now, I know that you're a partner, aren't you, at Leicester Aldridge? So that means you're a solicitor.
Yes.
And you work in the Disputed Wills team. So this is kind of contentious probate. This is wills gone wrong.
Unfortunately, yes.
Now, that sounds quite exciting to me, wills gone wrong. You know, I understand that you see these cases in the High Court and disputed estates and, people, I was always, before I suppose, became a bit wiser and a bit older, I always thought that, when you wrote a will, that was your kind of final document and, what you said went, but it's not like that, is it?
As I said before, unfortunately not. Wills can be contested. It's a common misconception that people have, that you make your will, you don't need to do anything further, and that's the end of the matter. Sadly, for some families, they find out after they have lost a loved one that that's not the case, and wills can be challenged. There are disputes involving estates and trust funds, and that's where I come in to resolve those disputes.
Wow. So I suppose there's kind of two aspects to this, isn't there? There's the first of all is to make sure that when you do write your will, it's as watertight as possible.
Absolutely.
So coming to you guys, etc., rather than maybe trying to do one yourself, may be the answer because at least you can get some professional advice. So I suppose a lot of it comes down to, do people want some strange things to happen to their estates? And then when, then the beneficiaries go, no, I don't want that to happen. Or that's not what mum and dad wanted or mum wanted or what have you.
Yeah, in England and Wales, you can leave your estate to whoever you like. So whether that's to a charity, whether it's to friends or family, but there are some caveats and there are some conditions that you need to know about, that if you do make provision for some people and not others, it can prompt claims against your estate.
Wow. Okay. And so if you're not in agreement, if you, let's say you are a beneficiary of an estate and you think, well, hold on, that's not how I was remember, or well, what's the first port of call? I mean, who do you speak to? I mean, you may even be, I suppose you could even be the executor of the estate, the person who's administering it, and kind of going, well, I thought I was going to receive everything.
Absolutely. I mean, my client base is quite varied, so I can act for families or individuals who may be concerned about a will or an estate and what's happened. I act for charities where they might be left a charitable legacy and are concerned that a dispute's going to hold up the charity receiving the money. I act for care homes who sometimes get brought into disputes over the deaths of residents, in that they're asked for information about the resident's health or their circumstances at the time when they made a will. So because I work with so many different people, needs vary. Executors will want advice as to how to progress matters in the best way and most cost-effective way. Sometimes they're also relatives, so they'll have a vested interest in the estate as well. And clients just want resolution. It's a very emotional time for most families. They've just lost a loved one, then a dispute arises, and it's very difficult. It's very stressful for families to have to deal with that. The types of clients that we work with, it varies from day to day. No 2 days are the same.
So what are the type of things that, I don't know, obviously you can't give me any personal information, but can you give me an example of the kind of cases that you deal with? And then maybe also, what maybe surprising resolutions may come out of it if they have to go to court and that type of thing?
I deal with a wide variety of cases. I specialise in court of protection disputes as well. So sometimes I'm brought in during someone's lifetime to resolve a dispute involving a vulnerable adult who may have lost the capacity to make decisions themselves. And we have attorneys who are in dispute with family members or with each other. So that's sort of one area that I deal with. The other sort of work that I undertake involves challenges to the validity of a will. In those cases, quite often there's suspicion as to how the will has been prepared or signed. It comes as a shock to family members sometimes to find out that they're not provided for in a will, or they are going to receive less than they anticipated. And I might also be brought in to deal with executor or trust disputes as well. So these types of claims, that they often arise following the death of somebody, unless it's a court of protection matter. And it really is one of, I think, probably the worst types of claims for somebody to face dealing with, because of the bereavement that often has happened as a precursor to the claim.
Yeah. And so, there's so many roles, isn't there? I mean, obviously an executor has, this is the person obviously dealing with the estate, who has the legal responsibility. Often these people aren't legal experts themselves, and knowledge of the different rules and regulations, it must be very difficult for a layperson.
It's incredibly difficult. I think it's tough for many professionals to have to deal with some estates, especially where there are really complex assets, maybe foreign assets, maybe complex trusts which form part of a will. So for a layperson, which is effectively a non-professional who's appointed to deal with the estate, it can feel an enormous task to undertake. It's also an optional role. Some executors don't realise that actually they have the choice of administering the estate if they want to, but many will also be a member of the family, and they might feel sort of morally obliged to want to help out. And it's an enormous task. You can have to deal with HMRC. You might have to call in and convert assets, which means selling assets, having them valued. If that's not your area of expertise, that can be quite challenging for many people. And I think for most lay executors, it's time. Administering an estate can be very time consuming. If someone is maybe retired or they have the time to spare, that's great. But many people will have dependents or day-to-day commitments. They may work, and having to deal with an estate administration as well can be quite time-consuming. So some people will employ a professional to help them deal with the administration of an estate.
So I'm just thinking of a number of scenarios that you could come across with, and a couple of that I've come across in my own professional career. So there was. There's the classic case, I suppose, of we see the movie when we see wills being read out at the movies. Everyone sat there in the office of the lawyer, and there's oh my gosh, a sharp intake of breath as they suddenly realise that it's all been left to Aunt Ethel or the Pony Club or something. So obviously, in circumstances like that, when that happens. What can people do if they feel that they haven't been looked after and they feel that they should be, included in someone's will?
Sure, it is that sort of gasp moment that we see in Agatha Christie films, or an episode of Poirot, or some crime drama when the motive to murder is inheritance. In the England and Wales, we don't actually have will readings. We might have family members come into an office to have a discussion about terms of the will, if they're beneficiaries or if they're an executor. But that just doesn't happen in the UK. But if someone is concerned about a will, generally there's different areas and different types of claims that we look at. So with the will itself, if someone's been ill at the time that they've made their will, there could be concerns about their what we call testamentary capacity. This is the capacity you have to make a valid will in England and Wales. This might be because somebody's been hospitalised, they've been diagnosed with dementia, and that's progressed to a certain extent. It could be that they are taking medication, which could affect their day-to-day cognitive abilities. And so someone must have capacity when they make a will. And quite often family members will say, I couldn't hold a conversation with them. So how were they able to recall what their assets were or who we were? In other cases, it can be coercion, which is a concern. And that's quite common in a family situation, especially if you have maybe family members who live away, other family members who are closer and on hand to help out. And there can be this perception or misconception sometimes that someone is influencing how the will is being made. And then there's also what we call lack of knowledge and approval, where someone may not have understood or approved of the content of the will. Wills can be complex in some cases. We do use terminology which maybe some people will not be able to understand if they have health which has declined or because of their personal circumstances. And it's really important that someone understands what every clause of their will do. And where we see those sorts of queries being raised by clients or families, they'll say, I'm not convinced that will was valid. If it was made on that date, mum or dad may have been unwell. I don't think they would have been able to make a valid will. And then we see worse cases where fraud could be involved. And that's where the testator, the person who's made the will, has no idea it's been prepared. What's happened is someone has either forged a signature, or they have prepared a will and signed it themselves, hoping it will be passed off as someone else's will. There's a very, infamous case now of Dr. Harold Shipman. It's well documented that he was convicted of murdering his patients. He was a GP in England and Wales. Sadly, has since died. But in his case, his crimes came to light because the daughter of one of his victims was a solicitor. And she knew that her mother wouldn't have made a will leaving everything to Dr. Shipman. And everything began to unravel. And they discovered that, in fact, the will was forged. And that's where the police investigation started from. So we do see cases of fraud. They are, I would say, sort of still fairly rare. We don't have lots of fraud cases, but they do happen sometimes, especially with vulnerable adults who may be susceptible to needing support from others, and others then take advantage of that. So there's all sorts of will validity claims that we see, and then we have claims against estates, which are slightly different, which ask for a share of the estate. That doesn't sort of challenge the validity of the will itself.
Yeah, there's a few cases that come to mind there. I think there was you probably know these because I'm drawing this from memory now, but I remember there was the last few years there's been quite a big case about a farm, and a farm left to a daughter, I think, or there was left, there was a promise, and then the promise kind of didn't come to fruition. You probably know more about this than me, so do you recollect the case?
Yeah, there are actually a number of farming cases,
okay.
Lots of famous farming cases, mainly because farms are family businesses, and you can apply it to any family business. If someone works in a family business with an expectation that if they are paid less than other workers in the business or receive nothing at all, that they may inherit it in the future, especially if someone gives that indication to them. The problem is, in England and Wales, you can change your mind at any time and leave your estate to whoever you like. So sadly, some people find themselves in a position of having given up their life to work on a farm or another family business, maybe for very little or no wages, maybe have given up the chance to go and work elsewhere, to have education at a higher level. And then they find themselves maybe having a falling out with a member of the family and they don't inherit. That's called proprietary estoppel. It's where a promise is made by usually a close relative that, one day all of this will be yours. Quite often that's just said in conversation. But if the person relies on the promise and acts to their financial detriment, they could actually have a legal claim against that estate. So people do need to be very careful if they do make those sorts of promises that they're not actually creating a claim for proprietary estoppel.
Right.
It tends to be in family businesses that we see those the most, but there are other cases where people have been promised inheritance and then they've gone on to pursue that when they discover they're not a beneficiary of the estate.
Yeah, yeah. And the other kind of case I've come across in my work is remarriage.
Yes.
So, husband was planning on leave, or the husband and wife were planning on leaving everything to the children. Wife dies. A few years later, husband remarries. And then husband dies. And the children of the original marriage were all expecting to receive mum and dad's estate. Mm-hmm. And suddenly the estate is now going, well, is in the hands, obviously purely in the hands of the new spouse, and yes, I've seen some unhappy people in those circumstances.
Yeah, I mean, now social dynamics have changed so much in the last sort of 50 years or so. It's quite common for people to have quite an extended family. They may marry more than once. They may have stepchildren or children that they just treat as their own. Some people don't realise, though, that can create certain types of claims in relation to their assets. The sort of step-parent, step-child situation is quite a common scenario that we see. It's very emotional because when the surviving spouse inherits everything, if then the children are excluded, they may have a claim against their deceased parents' estate. And they may also feel aggrieved if other family monies come into that estate. So if, for example, their parent who's died inherited from another relative, for example, a grandparent, they may feel that actually it's not just their parents' inheritance they're not going to receive, but also other family assets or inheritance which should come to their side of the family. So with stepchildren, it's really important to consider what provisions should be made for them because they can bring claims against estates in certain circumstances. And also to think about the potential claims which could be prompted. It's natural for most people to want to leave their assets to their spouse because they may think, well, where will the spouse live in the event that I die? And that's understandable. But if you also have financial dependents or children, even adult children and grandchildren, then you need to consider that they can bring claims against estates under what's called a shortened version, the Inheritance Act, the longer version, the Inheritance Provision for Family and Dependents Act 1975. And that act allows certain close relatives, ex-spouses in some cases, civil partners, cohabiting partners in some cases, children of any age, and more importantly, anyone you treat as a child. So if you adopted a child, if there is someone within your family, whether it's a niece or nephew or grandchild, if you treat them as your own child and pay their outgoings, they could have a claim. And also anyone who's financially dependent upon you. So because there is the ability to bring these claims, it's really important that wider families do consider provision for not only children and stepchildren, but also what claims could be brought in the event that they exclude children, because we do see these disputes fairly commonly.
Wow. So there's a couple of cases that I've come across recently. So one case where it was a small estate, and the people I knew had the relative who died lived quite a way away in Devon, Cornwall, and no, in fact, well, it was quite away from where they lived. Obviously, the member of family died. Next thing you know is everyone's let themselves into the house and taken all the belongings without the executor having any say into what was going on. And all types of kind of nightmare happened from there, obviously, with arguments and discussions and such like. What do people do in those circumstances where people are really just taking them, I suppose the law into their own hands?
It's quite a common scenario, unfortunately, and it comes from expectation, and that's what causes a lot of disputes that we deal with, is the sort of expectation that's mine, that was my relative, so why can't I take the family photographs or the other assets? The problem is that when someone dies, all of their estates are sort of is crystallised at that point. So anything they own, whether it's clothes, whether it's a car, whether it's their house or a share portfolio, all of that forms part of their estate. And then it has to be distributed either in line with the terms of their will, or if they haven't got a will, in line with the intestacy rules, which is a piece of legislation which dictates what happens to your estate in those circumstances. And it's usually your executor who is the custodian of those assets and then decides how they are to be dealt with during the course of the administration. The executor's role is to carry out the terms of the will or the intestacy, if there isn't a will. But in those circumstances, it is actually the executor who has that authority to look after the assets. It really shouldn't be for family members to go in and just sort of help themselves, but that does happen in some cases. There are things executors can do to recover those assets, because if they are removed without the executor's permission, technically they're taking an asset from an estate. Generally, though, hopefully families can liaise with executors. If they do want personal items, even if they're not left to them in the will, there maybe can be some discussion about that. And quite often chattels, the personal possessions, the photographs, the clothes, etc., they sort of go into a pot, if you like. And sometimes there is discretion to give them to certain members of the family. But I would always say that people shouldn't go into houses and just take items from an estate. Even if they know they're a beneficiary of the estate, they should liaise with the executor or the administrator where there isn't a will, and they should make sure that they have permission to access those items. People sometimes do it out of a need to help. So they may decide that in those circumstances, they want to go in and help pack things up. And it's understandable that relatives would want to do that. But again, they should let the executor know so that hopefully they can make arrangements together to do that and to clear a property or to pack things up or put things to one side. But it's really the executor's job to deal with the administration of the estate.
Yeah, it's quite a big job. And I think that people get appointed lightly and don't realise on the serious nature of the matter. The other case, and I'm sure again you may be familiar with this. I'm on a bulletin board for it may be a STEP bulletin board or trustee estate planning board, and I saw a discussion saying I've got one executor who won't deal with the other executor, and one won't give them a copy of the will, and they won't talk to each other, and I was just thinking, what a pickle. Do you get involved in circumstances like that as well?
Yeah, it's another very common area of claims that we have, executor disputes. So executors not getting on with each other, sometimes not getting on with the beneficiaries. On our website, on the Leicester Aldridge website, we actually have a blog that talks about sort of choosing your executors, because it's a really important decision. They have to be able to work together. So in lots of family situations, people may appoint someone to be their executor because of who they are. So if they've got 3 children, they may decide to appoint all 3 children. But you have to think that if those children can't agree on anything else, how are they possibly going to be able to agree on the administration of the estate and decisions that have to be made? So yeah, executive disputes are problematic for estates because it holds up the estate administration usually. It can incur costs. It can almost sort of stall the estate administration, and that's detrimental to beneficiaries. And also the person who's made the will wouldn't want for those delays and costs to be incurred. So it's really important when choosing executors to think about, do they get on? Are they trustworthy? Because in lots of cases, people maybe don't consider whether someone's able to manage money or have had a history of maybe mismanaging money, or they use someone who they're paying for that service, but they don't research the fees and charges involved. And then there could be huge charges for the estate. So it's really important to research who's going to act as that custodian of your lifetime's worth of assets, because you work hard for them. People build these, property portfolios, share portfolios. They work all their life to generate income. You really want to look after your estate and those assets.
That's right. Now, one question comes to mind, and I don't know the answer to this, but if I thought I could be a beneficiary of an estate, how would I find out? Can anyone see the will? What would the circumstances be when I'm thinking, well, I'm sure I would have. Aunt Ethel was going to leave me the tankard, on the bar, etc. How do I find out about that? Am I allowed to?
There's a few ways. Normally, only the people with an interest in the estate, so those who are named in the will, will be able to extract information before the grant of probate's issued. Once a grant of probate's issued by the probate registry, it's then a public document. You can actually search online to obtain a copy of the will and the grant of probate, so you can find out who's dealing with the estate as well, to make contact with them. And that can allay people's concerns. If they think that Aunt Ethel, for example, should have left them £10,000 in the will, they should be able, once probate's obtained, to get a copy from the gov.uk website. You can Google it. It's a search engine that's free. They do charge for copies of the wills, but that goes obviously to the government. But for £10, it can sometimes sort of put people's minds at rest as to whether or not they've received anything. And if they haven't and they're concerned, then there are steps they can take to then look into the will and what's happened with regard to the estate. Quite often it's the starting point for lots of claims. People check the will and then realise, I wasn't made that provision I was promised, so maybe there is a problem here, and then they look into things further.
Yeah, very interesting. And how far back do those documents go?
Quite some way. They're uploaded now as a matter of course when grants of probate are issued, but that wasn't always the case. Years ago, we would have hard copy documents and registers where you could search for that information. You can also contact, if you know someone who may have acted as solicitor for a relative, you could contact them and see whether they're prepared to give any information. They have to comply with client confidentiality. We have rules of confidentiality. But if you are a beneficiary, or they are maybe the solicitor's the executor, they may be able to tell you whether or not that's the case. But I will say that normally the executor will contact those who are left something in a will. So if you haven't had, quite often it can mean you weren't mentioned in the will. But if you do have concerns about it, look on the gov.uk website. You can obtain a copy of the will there, but that's only once it goes into probate. Before that, it's a private document. So it depends on whether others are willing to disclose that information to you.
Certainly. And of course, one thing that I don't think, I can see why people might want to just give the job to a solicitor to be the executor, because of course it removes the personality from the conversation, doesn't it? Removes the emotion, I think,
Sure.
From doing that. But I think maybe also that executors don't always realise just that if they are the executor, they can, even though they have responsibility, they can come and get legal advice to do the job.
Absolutely. I mean, you can instruct a solicitor to do part of the estate administration, so you can save costs that way. Or executors will sometimes say, I just don't have the time or maybe the skills I need to deal with some aspects of this estate, so I'll just hand over the whole administration. It doesn't mean they're excluded from what goes on. They'll still make decisions, they'll still be consulted about how the estate's to be dealt with. But it's that support network for an executor or a family where they don't have to deal with everything on a day-to-day basis. They have, if you like, a buffer that beneficiaries can contact if need be with queries. families. They've got help with tax issues if that's what they need. So sometimes people do like the comfort of employing a lawyer to deal with the estate for them. Others will just ask for portions of work to be done, and that's absolutely fine too. Some people will deal with the estate on their own, but it really depends on the circumstances of each executor as to what level of help they might need.
Certainly. Well, it's been fascinating chatting to you. A couple of last questions, I suppose. One of being of, if you feel, if someone was listening to this and thinks to themselves, well, I think something was wrong with something within a state that I was a beneficiary of or should have had an entitlement to, what do they do in the first instance?
Some people will do some research on their own. They'll maybe talk to other members of the family, see if they can find a copy of the will. If someone has a real concern about an estate, or they've made some inquiries and have hit a brick wall, they can't find any more information, they might come and see a solicitor like me, who specialises in will and estate disputes, to try and obtain further information. So, for example, if they're concerned about their parents' health at the time the will was made, we'll obtain medical records, we'll review them, see if that throws some further light on how the will was made. We can obtain copies of a will file, so we can actually have a look to see what was discussed at the time the will was made. And that may help to clarify things for someone who has concerns. There are lots of different steps we can take. We can contact the executor and the other beneficiaries and try to progress matters and reach a resolution for family members. It's not always possible in every case, but often there are options to investigate what's happened and to try and give some clarity to family members.
And I suppose, what's the right way, or what's the best way someone can try and prevent this even happening in the first place, even reaching your doors?
I wish I could say that there are lots of ways that you can guarantee there's no claim against your estate. Sadly, there's not, but there are steps you can take to try and limit risk, to try and avoid these sort of common problems we see arise time and time again. You mentioned the step-family scenario earlier, so maybe in that situation, thinking about provision for spouse and children in that case. I'm actually doing a webinar tomorrow on 10 common errors that we see when making wills and how to avoid them. That will be available on our website later, on the Leicester Aldridge website. There are things we see that people really should avoid. So learn how to sign your will properly. It may sound simple, but there's a set process to witness a will to make it valid. In fact, there's a newsflash, because over the weekend on the 25th of July, we had an announcement from the government that actually the new ways that we've used to make wills during lockdown can create valid witnessed wills. So this means that video conferencing can be used in some circumstances, and witnessing a will from the other side of a window because of social distancing can create a valid will, whereas previously that wasn't possible. What I will say is that the Ministry of Justice has advised that if you can make a will in the usual way, you should still do so, but there are now these other options up until 2022, when that law is due to expire, so it's only a temporary measure. So signing the will, really important to get that right. Choose your executors to avoid disputes. Think about provision. Think about who could claim against your estate if you weren't to make provision for them. It shouldn't be the driving factor, but it should be something that's taken into account. Who drafts your will? In England and Wales, will writing is completely unregulated. So just because you might go to an online company or a specific firm that you see advertised, there's no guarantee that they will have experienced people preparing a will for you. Sometimes there's hidden charges because the variety of services varies greatly. Solicitors have to be transparent with their fees. We have to advertise them openly, and they'll give you cost estimates. I have come across some companies where there are, should we say, deeply buried charges which people only find out about after the death of their loved one, and it takes a huge chunk out of the estate when they have to pay those fees. So really research what service you're going to use. Don't go on online recommendation only. So when you see these reviews online, you take them into account, but they shouldn't, make the decision for you. If a friend or someone has had a good experience with a company who draft wills, whether it's a solicitor or someone else, maybe go to that company. Make sure that you're investing time and thought into the will making process, because as I said earlier, you're dealing with your lifetime's worth of assets, and it's really important. Some people use a will as it's sort of a last thought, where people say, well, I don't really need to spend much time on this. It's not about how much money you spend, it's about the thought that goes into the process. Generally when you're making your will, just consider, if you sat down today and listed all of your assets, just how much those assets are worth, and the fact that you would want to protect them. So it's really important that a will is drafted properly, that you have executors, you sign it properly. If you've had ill health at the time when you've made your will, could it be challenged? You can see a solicitor about these issues, whether it's someone like myself who deals with disputed wills, who can maybe look at it from a different perspective, or maybe have a chat to your probate solicitor who's preparing your will for you about your concerns that the will could be challenged. And they can sort of look at your circumstances, because every case is different, and give you advice on how to limit risk in those circumstances. There's lots of things we can do to try and record everything, make sure that the will be valid as much as possible, and to ensure that someone's wishes are hopefully carried out.
Yeah, because not only you have got a document that you've got a will, but seeing a professional like yourselves, you've actually got all the file notes of actually what the intent was, haven't you? Which, of course, I'm sure that's very useful when you get to court, if you ever do get to court, with all those file notes of exactly what someone was trying to attain or trying to do.
Sure. Yeah, it's so important to document your wishes, because the will itself is a snapshot at that particular time of your circumstances. If it was made 20 years ago, it's not going to reflect your current circumstances. Maybe you've had more children or grandchildren since then, or you've married or remarried. So if you're using an old, outdated will, it's as bad as having no will at all in some circumstances. So it's really important. Reflect and review as your circumstances change. And if you need to update your will, do so. So then you have the most accurate picture of what you want to happen at the time sort of closest to your death. None of us can predict when we're going to die. But if you regularly update and review a will, it's more likely to reflect your current circumstances.
Yeah, absolutely. Well, I'm sure contested estates are probably not going to go away anytime soon. So hopefully we'll have your expertise alongside us, Victoria, for many moons to come. Thank you so much for your time this afternoon. It's been great to chat to you, and really interesting. So we'll put all those links on the show notes where people can find out more information. And where can people find out more about you, Victoria?
Well, Leicester Aldridge, we're based in Bournemouth, but we have offices in Southampton and London. On our website, www.leicester-aldridge.com. You can also find out all our blogs, and throughout the lockdown and COVID-19 situation, we've been blogging constantly, trying to update clients and the general public on the ever-changing landscape of how we execute legal documents and wills. So there's lots of information on that, and also some of the things we've talked about today, some of the types of claims. There are pages on our website which actually go through those claims and the issues in detail. So if you want to know a bit more about testamentary capacity, there's information on our website. If you want to know who can claim against your estate, look under the Inheritance Act section of our website. It's all there. If someone would like to contact us as a firm, if they've got a query about a disputed will, they can contact me. My contact details are on the website too. We actually offer a free 30-minute initial discussion for someone who's concerned about a will or an estate, or wants to bring or defend a claim, or executors who are having problems. So they're more than welcome to contact me. We can set up an initial discussion and hopefully allay some of their concerns.
Brilliant. Well, I'll put all those links, as I say, in the show notes where you can find those. Thank you once again, Victoria Jane.
Thanks, Justin. Great to speak to you.
So until next time, this is Justin King, helping you feel more informed in your retirement.